Well, hello, how are you? Let me just see if I can get into this circle. Whoops. See if I can get into this circle. Hello, it's been a while. How are you all? Hope you are well. Uh, I'm, I don't know, I'm a bit iffy at the moment, so I don't know really what's going on, but I just thought I've got some time today, and I thought we would try and catch up with this lawsuit because there's been so much that's been happening, and it's been a while, and I thought let's try and look at this and see if we can catch up on it all and see what we can do. So say hello if you're watching. If you're going to be on the replay crew, hello again. I might make this a square, I think. That's better, right. Yeah, so, feels like there's been so much that's happened since we last been here. So I've got a new car now. It's funny, I got the money back for the car, finally got written off. I cancelled my registration, and then they've said there's a computer error and they can't pay me electronically, so they're going to have to pay me by check. And then once they pay me by check, the bank's going to charge me $5 to take a check, to put a check in the bank. I mean, come on. It's really bizarre. Anyway, so we want to catch up with, and I can't even remember where we got up to with this, but there is so much that's happened since we last spoke. You've been looking forward to seeing it. Hello, Bella. How are you? I'm okay. I've got a bit of a headache at the moment. I'm just struggling, but we're going to be okay. It's fine. All right, so let's have a look. As I said, I've been trying to work out where we're up to. So we may have to go backwards a little bit to go forwards, if that makes sense. So, and StreamYard is completely different to what I remember as well. So I'm just going to remove myself from here. Okay, so we've got here. So there's a hearing on the 3rd of April at 1:30 p.m. Okay, so so there was a matter that was taken under advisement on the 11th of the 3rd. So I'm assuming that's this bit here. There was a hearing on the 11th of the 2nd. A notice of hearing on the 11th of the 2nd. There's a notice of, it's a remote hearing. There was a hearing in person on the 9th of the 2nd. There was an interim brief due. There was some proposed. So there's a whole pile of this. So I believe they had to refile stuff. So cover sheet for non-public documents, proposed order. So we're going to have to go down. I think, because it's been a while. So it's been a while. So we're going to have to go back, I think, to the other hearing, I think. So, because I didn't even read, I know there was a hearing at the end of December, of course. Hearing on the 17th of the 10th. Yeah, there was that hearing. I think we covered that one. Then there's been all this other stuff. There was a hearing, wasn't there a hearing at the end, December 30th or something, wasn't there? I'm sure there was. Oh, yeah, the 31st to the 12th. Yep. That's it. Then there's the next hearing. So, yeah, so we're probably into this bit of stuff here. Although that's an 89. I think they had to redo some stuff, didn't they? So, what I'm interested in, though, is the decision. Where was so there was an interim brief under advisement. Oh yeah, there was a finding here. This is it. This is what I was interested in. I wanted to see. So let's look at let's look at the findings from the 17th of December, and that hopefully should give us some context into what all of this other stuff is. But it's still going ahead. There's 41 pages here. It was a big document. And there's been stuff refiled. All right. If I look like I'm all over the place, yes, I am. I'm a bit all over the place at the moment. So, all right. So this is order granting in part and denying in part. So again, it was only a semi win in lots of cases, to be fair. You know, just a semi win. So it says, now this is really important. When the judge makes her decision, so when she's making her decision, okay, she's making it, and this is really important, okay? This is really, really important to remember. Based on files, records, and proceedings herein, and the parties' memoranda, okay? It's not based on, she's not making it based on media reports or news or other articles. It's purely, wholly, and solely based on the court files, everything that is in the court. All right? It's not about he said, she said. It's got nothing to do with any of that. So the judge doesn't care what, what other people are saying. It's everything that is in court. That's why it's important to get as much information into the court as you can, because that's what they use it on. So this was her last decision. So this was the motion for reconsideration. So we've got the finding of fact. So when we talk about findings of fact, this is everything that we know to be true. Okay? So this is fact as opposed to everything else. Okay? So this is usually upon agreed facts. And anything that's not agreed upon is what is argued. So the fact that Katie Joy is a journalist is not a finding of fact, or an investigative journalist is not necessarily a finding, unless the judge says that it's a finding of fact. And you can take these as gospel sort of things as well. So it's sort of gospel as far as, because it's a finding of fact. Okay, so we know that on the 31st of 2022, plaintiff 7M filed a talent management company. So this is, again, very important to add. 7M, talent management company, okay? And its CEO and sole owner commenced the lawsuit. So Without a Crystal Ball LLC, a Minnesota resident and corporation. She runs several social media accounts with substantial reach, numbering in the tens or hundreds of thousands of followers and attendant engagement, particularly on Instagram and YouTube. Fact. Shortly after, the complaint was amended to add Miranda Derrick and James Derrick as plaintiffs. In essence, plaintiffs contend that the defendants reporting on them has lowered their estimation in the community to the extent they have lost contracts, brand deals, resulting in significant financial loss. That's a fact. Plaintiffs assert that the information reported by the defendants is false, and that Ms. Paulson either knew it was false or acted in disregard of its truth or falsity. All right? Defendants' amended complaint contains 85 statements they describe as false allegations to support their claim. On June 23, 2025, the court entered an order denying plaintiff's motion for summary judgment and granting in part defendant's motion for summary judgment on count 1 regarding statement numbers 12, 21, 31, 39, 40, And then on June 25, defendants filed correspondence with the court seeking permission to file a motion to reconsider based on clear legal errors involving the fundamental First Amendment protections that are dispositive of the plaintiff's claims. Plaintiff opposed defendant's request. So far, these are the read facts. July 10, they entered an order granting defendant's request to file a motion for reconsideration based on the court's finding that compelling circumstances existed under the Minnesota rule, including in part the extensive litigation history of this case, the complexity of the legal issues presented to the court, and the lots of allegations. So the motion in support of their motion to reconsider, defendants argued the court did not determine whether each allegation contains statements of fact or opinion as required under the First Amendment. Defendants argue that the statements made by Ms. Paulson are non-actionable opinion, theoretical hyperbole, or subjective interpretation of disclosed facts. Plaintiffs' implied defamation theory is legally deficient. Plaintiffs have failed to prove defendants acted with actual malice by clear and convincing evidence. Plaintiffs' tortious interference claim fails as a matter of law because it is based entirely on protected speech. The court erred in allowing plaintiffs' negligence claim per se to proceed under Minnesota, and plaintiffs refused to produce discovery requiring damages despite a court order. As such, they seek summary judgment. Plaintiffs opposed the motion and claimed that the defendants are abusing the stated purpose of Rule 115.11. Motions for reconsideration should be approached cautiously and used sparingly. Courts may exercise their power to reconsider decisions where the earlier decision is palpably wrong and in some respect. So the court finds the defendant's motion to reconsider borders on presenting arguments that were available in regard to defendant's prior motion, but were simply not made. Defendants based almost entirety of their motion to reconsider that on the argument that the statements made by Ms. Paulson were non-actionable opinion. In that regard, they provided detailed discussion and analysis on the issue of whether the statement is opinion or fact. This argument was not presented in the defendant's 69-page summary judgment motion, with the exception of conclusory statements that Ms. Paulson's reporting consisted solely of statements of non-actionable opinion. At best, arguments made in the defendant's motion to reconsider are expansions of their previous argument, and defendants are walking a fine line here between presenting argument that was available when the prior motion was considered and expanding on previous argument. Nonetheless, the court finds that it's in the best interests of the litigants and the court to address these issues in accordance with procedural and persuasive legal authority. That's interesting that they're talking about a fine line. All right. So they've done it. For the foregoing, the court finds it appropriate to reconsider the summary judgment. So then they go through the pleading requirements of what you've got to do. Whether a statement is question of fact is a statement of law. The court determines that the statements are opinion. The inquiry ends. The statements of opinion are protected under the First Amendment. However, if the court determines that the statement is factual, the analysis of whether the statement was defamatory proceeds. So now we're going through the elements of defamation. So remember that it has to be communicated to one or more persons. It has to be false, and it harms the person's reputation. And the recipient of the false statement reasonably understands it to refer to a specific individual. Truth is a complete defense to a defamation action, and true statements, however disparaging, are not actionable. But see, I find it very, very interesting that she's never actually pled the truth defense. And that to me was or is or has been her strongest case, but she never pled. She's only ever talked about her First Amendment rights. But if she had said that they were true or partially true, I think Katie Joy would have had a stronger case. But anyway, as a general rule of law, truth or the falsity of a statement is a question for a jury. If the words are capable of a defamatory meaning, it is for the jury to decide whether they were in fact understood. Okay, so then we get into the malice. If there is a public figure, the plaintiff must prove the defendant with actual malice. And again, whether she's a journalist or whether she's whether they're public figures has, as far as I am aware, have not been determined. There could be some other stuff in here. Reckless disregard for the truth is a subjective standard. Actual malice may be shown if the statement is fabricated by the defendant, is the product of his imagination, is based wholly on an unverified anonymous telephone call, or if the publication's allegations are so inherently improbable that only a reckless man would have put them in circulation. That, to me, in my opinion, sums up Katie. A reckless. The proof of actual malice calls a defendant's state of mind into question and does not readily lend itself to summary disposition. So, for example, Miranda Derrick was lured into a church, 7M. 7M is associated with the 7 mountains of influence. 7M believes they need to take over all spheres of the world. For Christ to return to the earth, the M in 7M stands for mountains of influence, a Pentecostal belief to take over the world. See posts for specifics. So then we've got here, there's a footnote here somewhere. What's that? 2. Miss Paulson offers various statements regarding the formation and origins of the plaintiff 7M, including the 7M theology believes that the apostles received direct revelation from God, placing his followers in submission into these revelations. This is not biblical at all. 7M is dangerous theology. The statements are verifiable, precise, and specific regarding the supposed beliefs and foundation of Plaintiff 7M. Furthermore, the statements are made in the context of Ms. Paulson's social media platform in which she identifies herself. This is interesting. She identifies herself as an investigative journalist. So not saying she is, but she identifies herself. So if I identify myself as a supermodel, I can identify myself. You can identify yourself as anything. That doesn't mean it's true. They are not made in the context of satire or other fictional commentary. As such, statements are asserted as fact. It is not the court's province to determine whether the statements are true or false. Additionally, a reasonable jury could determine the standards harmed 7M's reputation and lowered their estimation in the community, as reflected by the alleged significant financial impact defendants' reporting had on the plaintiffs. Furthermore, the evidence in the records could support a reasonable jury finding either that plaintiffs have shown actual malice by clear and convincing evidence, or that the plaintiffs have not. Because Miss Paulson's state of mind is relevant to whether or not she acted with actual malice, the court finds summary judgment is not appropriate in this allegation. So then about the coerciveness here. So it says 7M is using religion to control time, money, resources of dancers that were vulnerable to abuse due to their economic status. They were abusing dancers. So she says in the summary judgment exhibit, they have 2 separate links to support this allegation. However, the only link that worked is from an Instagram post beginning with a news source reached out that knows other dancers in the crew. So they have talked about that. Whether 7M is a cult is not susceptible to different meanings, and that statement in or of itself is not factual. However, the court finds that in the context of the entire post, Ms. Paulson is presenting information that is verifiable, precise, and specific. Furthermore, the statements are made in the context of Ms. Paulson's social media platform in which she identifies herself as an investigative journalist. They are not made in the context of satire or other fictional commentary. So again, this one's going to go to the jury. It's not the court's province to determine whether the statements are true or false. See, this is where she could be in trouble, because she's identifying herself as an investigative journalist, and it's all they're saying it could be asserted as fact. You see, the dance is managed by 7M. They don't pick their, again, we've got this. she identifies herself as an investigative journalist. It's very important to remember that because she identifies as an investigative journalist. They've not said that she is. And again, she's just repeating the same thing. B dash is the nickname for James Derrick. So again, 7M is providing on 7M blocks friends. Much of this is attributed to Samantha Long, a former friend of Mr. Derrick's, who spoke out about her observations and interactions with Mr. Derrick. Additionally, Miss Paulson makes independent statements in the caption such as, some family don't even know if Mr. and Mrs. Derrick marriage is real, and judgment is controlling everything, or management is controlling everything, even the social media. So many don't know how to reach the dancers. These are specific statements of fact which are objectively verifiable by social media managers, dancers, and dancers' families. Furthermore, the statements are made in the context of Miss Paulson's social media platform. And again, they've said, furthermore, the evidence in the record could support a jury finding either that plaintiffs have shown actual malice by clear and convincing evidence, or the plaintiffs have not. The 7M is committing crimes. This is a very lengthy recording of a live Instagram reel. The allegation in the complaint does not identify which specific statements in the video are defamatory. Instead, it is a conclusory description of what Ms. Paulson addresses in the video. Plaintiffs do not offer enough specificity to provide notice to defendants of the defamatory statements that Ms. Paulson allegedly made. As such, summary judgment is appropriate to allegation 6. However, the plaintiffs may move to amend their complaint, and I think they have. Again, a live Instagram reel. So again, because it was not specific. Again, they've said they may move to amend their complaint, and as I said, I think they did. Clients are falsely married to their spouses. Again, that's the so she's gone through each of the claims here. I mean, this would have taken ages. It's 41 pages. It's a very long, as I said, very long. So it looks like both, again, just like with the evidence, it's like discovery that some went one way, some went the other way. You know, like it's not so remaining claims. It is unclear from them. Yeah, so there was some discovery stuff. So yeah, so again, it was granted in part. It wasn't a win. Okay, so anyway, so that's where we are. So then we've got a responsive motion here. What's this one? All right. Hello. Oh, look, it was a last minute thing, Michelle. I just decided to do it. I just thought I hadn't been here for a while. I hadn't been here for a while. Let me put my... I hadn't been here for a while, and I thought I may as well say hello. I'm just trying to catch up on all of this Katie Joy stuff. So this was... This was another thing that they put on their memorandum opposing motion for contempt. So there was obviously a motion for contempt filed. Let's have a look, because that wasn't the next document. Oh, wait on. Responsive motion. Where is... What's that one? So there was a motion of contempt filed. I don't know who that was for, what that was for. Okay, and of course they opposed, the injunction was opposed, by the way, because they had tried to stop her talking. The thing about it, if she keeps talking, it's just going to help. But what they're saying is that it's going to be too hard for the court to maintain the for the injunction. So that's also happened. I'm just trying to find out what on earth is what it is here. All right, there's a motion there, other document. There's so much here that's been filed. So there was another order. Notice of remote there. So there was a interim brief due. So there was an 88 page document filed just in here. Let's have a look at this one. Yes, the Second Amendment. So they've amended it. So let's have a look at this. I'm going to jump through a few, all right? So we've sort of seen what's happened. So they've applied, so they've essentially gone and done it again. So they've done an amendment. So Second Amendment amended summons, okay? So this is the summons. Again, so the factual background, again, this is background. So that will basically be the same. What they would have changed is some of this stuff where they've put in here the exact allegations, because that's what they had to do. They had to actually list the allegations in here. And so these are so where they've said so they've put in the time set. So I cover a lot of cults. I'm pretty familiar with how cults work, and I'm pretty schooled with about all the tactics they use. And they've got here, they're putting in the timestamps so that the court can go straight to the spots. Miranda, I was told by someone today that collabed with her recently, was not allowed to be alone. And so they've just really made it all succinct. The engagement video is staged. I don't think they're married. I don't think they're even married. So they've gone through and they've just now listed all the exact allegations. The management is isolating the dancers and dictating their Spanx. Do you support cults that coerce every single aspect of a dancer's lives? Every decision is controlled by the pastor and his team. Slavery still exists. And again, so it says, and then it says Instagram reel deleted. Interesting. It's funny how she's going on about them deleting evidence, and yet she's, there's stuff that's deleted. Post deleted, see transcript. Post deleted. Post deleted. So part of this would be they would have the transcripts of the full transcripts here somewhere. Oh gee, this has been a wild ride. I mean, this has been going since 2022. And then she's got the 13th of the 8th, Miranda and James Derrick. Your friends are worried about US attorneys. Please indict and arrest Robert Shin. We won't stop fighting until everyone is free. And Robert Shin is in prison. So they've added new stuff as well. Robert Shin attorneys have failed to respond to my attorneys for almost a month. Despite an ongoing lawsuit, Robert and crew have all but abandoned the case. His attorneys are ignoring our emails, and we have been forced to notify the judge of the criminal investigation against him. I'm fighting this lawsuit to the end. I will not say that settle. I will not be silenced. Every settlement that I've ever been pushed into came with one condition: my silence. And I regret every single time I agreed to stay silent. Never again. And again, this is the 31st of the 12th. That was, remember, when she said about her demands. Then they've talked about continued disparagement. So, yeah, so they've refiled everything, essentially, with all that extra stuff in it. Right, so who's this? I mean, this is a lot of stuff to take heed of. So this is, oh yeah, this was, that's right. They wanted contempt charges filed. That, so they wanted, it was filed by, clearly required defendants to respond to plaintiff's request for production documents. Defendants actually received an actual order of the court. So they want Katie Joy to be filed for contempt. So this is the proposed. So this is what I believe is under advisement now, because they haven't done it. And then this is from the other side. I amended motion for discovery sanctions to reclassify documents. Oh dear. So now, yeah, so this is what Katie Joy's side has filed. So this is what's under advisement now, so we'll find out which way it goes. Plaintiffs did not produce any financial. I still don't believe the plaintiffs needed to file any personal tax information. They only needed to provide it for 7M. And it's interesting. Plaintiffs did not produce any financial for approximately 19 months. Defendants sent deficiency letters, and then in September 2025, they produced 7M's tax returns, financial statements, and some payout schedules. Well, that's what they were required to do. The production did not include social media platform monetization records, payments made to creators. The deposition testimony of Miranda and James Derrick establishes they were aware of and testified about platform monetization. And then they're talking about deactivation of the accounts. And they want all the records taken away from that. And then they want to put in new evidence. It's interesting. It says in their September 17 affidavits, they swore no criminal charges have been made against me regarding the defendant's statements, related to defendant's statements. This carefully worded statement does not address whether federal investigations exist. But that wasn't the part. That the point is that she was saying that he was going to be charged. So they want contempt charges. Both sides want contempt charges filed under the other. It'll be interesting to see what happens. They want Discovery reopened. It's interesting that their thing is like huge. So it says Robert Shin's prior deposition did not cover the federal raid. Well, it wasn't relevant at that point, and it's not. It's still not relevant to this case. So plaintiffs, yeah, they want the civil contempt denied again for the plaintiff and granted their side. So this is they want so much here, and then they want discovery 60 days, and they want to depose Hannah Shin and Shirley Kim, depose Robert Shin and Miranda Derrick and James Derrick. But as I keep saying, it does not. It makes no difference whether that federal case, if there's been no charges filed, it's a lot of money if she's found in contempt. A lot of months have gone paid since order made. Not to mention, really, she could do that. So this was the plaintiff's about contempt. It's really messy. I know I've sort of skipped through a lot of it, and I'm just skipping through it because there's so much to get through. So look, plaintiffs expressively outlined defendants' failure to produce the following. It's interesting that 7M is saying that Katie Joy hasn't presented her financial information. And who the sources are. So I'm just finding it very interesting that what Katie Joy's accusing 7M of is what 7M's accusing her of. She is, Michelle, I think she's acting as if she's the plaintiff. It's very confusing. So yeah, it's definitely interesting. So it looks like this is what they're both filed motions for contempt against each other, and the judge now has to decide. I mean, and don't forget, it'll be based on all the filings. She'll go back and look at her all of her other. No wonder she slipped up on some of her responses. Yeah. So this is an affidavit to the defendant's discovery sanctions. So that's a meet and confer. And so she's listed her dates. And that's Exhibit A. So what she's saying is, I think, she's sent to defendant's counsel. She's not received any communication regarding discovery requests. So it's interesting so Katie Joy is saying, oh, they won't meet with us, but Amber's put in to the record that here, I sent them a letter. Here's the letter. They never responded. Oh, this is Exhibit 3 of the 11th. The 11th. Oh, there's nothing there. Oh, yeah. Well, no, we're just waiting. There's 14 pages here. This is Exhibit 3, so there must be more to it. So what date's that? 17th of the 12th. This letter is so hard to read. Who writes in this font? Oh, I have to read. Let me read this letter because it's very interesting. Okay, I've yet to receive a response from you regarding the scheduling of depositions for Hannah, Shin, and Shirley Kim. It is my understanding that you refuse to accept service for them because they are not your clients. This is not a legally sufficient answer. Both individuals are identified in your initial disclosure as being available for you. Both appear to do work for your corporate client, 7M Films. But just because they did work for 7M doesn't mean that that person's really this is bizarre. In short, there is no legal theory that supports your position, and we should not have to domesticate a subpoena to arrange for personal service. I don't know how it works in over there, but in Australia you have to appoint a representative. If you want to dispose somebody, and you either have to do it to the person in person, or you have to actually do it to their legal representative. If they don't have a legal representative on file, then it's to the person. So she should be sending the stuff to Shin and Kim. In short, there is no... If you do not communicate with me by the end of business on June 10, 2024, that you accept service, I'll arrange for a domesticated service of subpoena upon them and charge the cost to you. I understand you're being treated with thyroid cancer, but you agree to discovery deadlines, and I will have these 2 depositions. In fact, I have to have this service domesticated. I'll produce a subpoena for Isaiah Shin, and we'll look at deposing some of the other dancers who were working with 7M Films at some time. At the time the statements in the complaint were made, since they have evidence related to statements you claim my client made about your housing arrangements, tithing, dance choreography, and wardrobe that your clients believe were defamatory. I've reviewed your discovery response, and I note that your client provided discovery only up until the date of discovery requests were served. Minnesota rules imposes a continuing obligation upon parties to provide updated discovery upon the receipt of new information. At the very least, that would require your client to provide 21, 22, 23 tax returns, current financial statements, and information related to all contractors and employees present. Okay. To present, upon receipt of your client's tax returns, Ms. Paulson will provide hers. If you do not receive this information prior to depositions in this matter, deposition will include a motion to dismiss plaintiff's claims based on the failure to provide discovery related to damage. What date was this? So this was in June 24. There's a trial in this matter. Ms. Paulson will ask for a negative inference that the documents have been produced. They would not support your client's claims for damages. The failure to provide basic discovery, such as tax returns and financial information, suggests that your clients are not serious about litigating this matter. Rather, it would appear that your clients use litigation in a ham-fisted attempt to shape public opinion and bully content creators into keeping silence about their experiences with 7M Films and the Shekinah Church. Shekinah Church isn't a party to the information. This appears to be buttressed by the recent Netflix documentary Dancing for the Devil, the 7M TikTok Club, wherein former dancers and church members made the exact same allegations your client claimed to be defamatory in this lawsuit. Your client did not sue Netflix or Dirty Robbers, the production company associated with the limited series, for defamation. More evidence that your client only goes after individuals who do not have significant resources to defend themselves. It is past time for this lawsuit to end, but your clients cannot see their way to protect themselves against the bad publicity that would be engendered by motion practice and trial, in this case, by dismissing the matter. It is a very long time for your client to show that they have suffered damages as the result of the statements they claim Miss Possum made. Isn't that very interesting? Then this one was July 26th. I mean, she's pretty rude. Why did she have to mention thyroid statement? So then she's put in a court order there. So anyway, I just find it just bizarre that the way that she's used that. Responsive motion affidavit, yeah, memorandum. Yeah, so that was in 2024. Oh, it's just, yeah, so there's been hearings and such. So it's getting messy. It's really getting messy. So I think they were granted the opportunity. I mean, if she gave the Katie Joy to respond, you know, to redo for reconsideration, surely she's not going to deny. So yeah, so April 3, there is a hearing. It is a remote hearing, I believe. So April 3. Which again is in a couple of weeks' time. And then you've got to wait for consideration and all of that sort of stuff. Yeah, so she's taken under advisement. So I guess we're going to find out. Let's have a look at the history of this case. Look how long it is. So 7M spent $1,420 on filings, and Katie Joy spent $1,400, $1,420 on filings. So that's just for all the. So that's what it's costing them at the moment. So there was a pre-trial hearing on the 9th of the 2nd. And there was a motion hearing coming up on the 3rd of April. Oh, so that's a motion hearing, okay. So yeah, it's a little bit messy, to say the least. It'll be interesting to see what she does, whether she does use her husband's medical stuff. Now, there's actually been a very interesting case in Australia, believe it or not. Very interesting court case in Australia. And it's called the Katy Perry versus Katy Perry lawsuit. It went for 17 years. And what I find to be really, really interesting is that you've got the Australian-born Katy Perry versus the pop star Katy Perry. And it's interesting because Katy Perry Australia was born Katy Jane Taylor. I think Perry's her married name. And of course, we know Katy Perry, it was born Catherine Hudson. Now, interestingly, Katy Perry Australia is Katie, and Katy Perry pop star is Katy. Now, what happened is that Katy Perry Australia, Katie, produced a fashion label, produced a series of clothing under the name Katy Perry, Katie, as opposed to Katy. And she got sued by American Katy Perry for trademark breach. Katy Perry registered her clothing brand in 2008. Well, the singer later sold Katy Perry branded clothes on her Australian tour. So, in 2023, the designer, she won. Then she appealed. Then it was appealed in 2024. Katy Perry, the pop star, appealed, and it was overturned at appeal. But then it went to the High Court of Australia, which is the highest court in Australia, and that overturned the appeal, restoring the designer's rights. So it rules as a landmark Australian case regarding the limits of celebrity reputation against registered business trademarks, stating that stars cannot simply rely on fame to override existing similar trademarks. So, yeah, it's very, very interesting. Katy Perry versus Katy Perry. So let's see if we can find a really quick summary of this case. All right, here we go. This is from a law firm called Coulter Legal. But it's very interesting, isn't it, Michelle? Katy Perry versus Katy Perry. So it was a trademark dispute, okay? So Katy Perry, High Court to hear trademark dispute. Yes, so they actually did hear it and she did win. So an Australian fashion designer, Katy Jane Taylor, nee Perry. So Perry was her maiden name. Okay. So in 2002, Katy Perry adopted the stage name Katy Perry. In 2007, and the Australian designer filed a trademark application for Katy Perry. However, this application was allowed to lapse. In 2008, she was first made aware of the US pop star. Taylor then registered the trademark Katy Perry in Australia for her fashion label. Subsequently, the US pop star started selling merchandise under her stage name Katy Perry during Australian tours, ultimately leading to a legal battle over trademark infringement. In 2023, the federal court ruled in favour of Taylor, finding that Perry's merchandise sales during her 2014 and 2015 prismatic tour in Australia infringed Taylor's trademark. However, late in 2024, the full federal court overturned the decision, stating that Katy Perry had been using her name as a trademark in Australia well before the priority date of Taylor's registration. The court also found that Taylor's trademark registration was likely to cause consumer confusion and ordered that to be cancelled. Dissatisfied with the outcome, Taylor sought leave to appeal to the High Court, and so it was hearing the case. So that's essentially what happened. Look, the other thing is, I also believe that, would you be confused by Katy Perry and Katy Perry? And look, here is Katy Perry, the pop star, and Katy Perry, the fashion designer. Michelle, Katy can't have everything. A hot former Canadian Prime Minister and the trademark too. Yeah. Oh dear. So yeah, so in 2009 when she was touring, Yeah, so Katy Perry, the designer, was born Katy Perry. And so here's the other thing. Right? Can somebody who adopts a stage name take ownership of a name they weren't born with? So that's the thing. I mean, how can somebody who has been born with a name? So let's just say by chance somebody changes their stage name to Joanne Cochran. Should they have ownership over that name, considering that that's the name I was born with? So it's very, very interesting. So there's definitely a yeah. So it's been going on for 17 years. Now the other thing is that just because you have a trademark in one country doesn't necessarily give you the right to have that it's trademarked all around the world. So it looks like now when Katy Perry comes to Australia, she's going to have to rename her merch. Yeah. So yeah, it's a very interesting case. So have a look, and um, costs have been awarded in the Australian Katy Perry's favour. So now Katy Perry pop star, so you got Katy Perry pop star now owes Australian Katy Perry costs. How imagine trying to get your head around that. I mean, you think there's 7M Katy Joy things confusing. Try working out Katy Perry versus Katy Perry. As I said, you got Katie versus Katy. Oh dear. Oh dear. Trying to get your head around it, hey? Oh dear. But I guess what is good is that the Australian business has won, and the little guy has won, and maybe she could be uber cool and get Katy Perry to do her Australian merch. Why can't we be friends? Well, yeah, that's right. Mhm. No, you're confused? Yeah, it's very confusing. American Katy Perry versus Australian Katy Perry. So, yeah. um, I also the King and Queen of Denmark are out in Australia at the moment, and of course, everybody knows that Queen Mary is Australian born, and they're touring Australia at the moment. Um, and we are just loving having them here. And they're going to Tasmania. I think they're going to Tasmania today, and that's her home. That's her home country. So the Prime Minister of Australia said this, which is true, because we sort of say she's our queen. Well, she is. If we could be part of Denmark, if we could have Denmark, like if Denmark could become our monarchy, I think we would be very happy to have Queen Mary as our ruler. Isn't she beautiful, Queen Mary? Anyway, across oceans and continents, Australia watch Her Majesty Queen Mary's work with admiration and pride. From beginnings in Hobart to the role beside King Frederick of Denmark, hers is a story that inspires Australians. Queen Mary embodies so many distinctive Australian qualities, including authenticity, kindness, humility, and a belief in community. That's why Australians still speak of her with so much affection. Her life has strengthened the bond between Denmark and Australia in a way no diplomatic agreement could ever. This visit to Australia is an opportunity to build those ties. From Australia to Queen Mary, we simply say thank you for representing our nation with grace, for using her voice to help others, and for showing the world what Australian spirit can achieve. And so they started off in Northern Territory at Uluru. Then they went to Canberra. Then they spent time in Melbourne. And she's got a pretty good kick on her for the football. And then they're in Hobart today. They've kept the schedule very quiet. I know they did go to they did spend some time at the Monash Children's Hospital and the Royal Children's Hospital and spent some time with families there. And I know that King Frederick played table tennis with some people, some teenagers who were having some mental health issues. So that would be really good. So anyway, hopefully you've enjoyed that sort of catch up. It's a bit scatty, but I'm going to try and keep up with it again, more so, because we need to keep it going. I've just read something that the Queensland Young Australian of the Year has just been charged with child exploitation material. So does that mean he's going to have to they've found child exploitation material, videos, images of females under 16 on his work and personal devices, leading to charges. He's been granted bail, denies the allegations, and is presumed innocent. His court appearance is set for next month, with officials monitoring him closely. Whoa, that's a bit scary. Oh dear. Eight counts. It's pretty scary. There was a children's writer, a children's author in Perth that was charged for something similar as well. What is wrong with people? And it was a book that is read in Australian schools that now they've taken it off the list. All right, Craig Silvey. He's an award-winning author. What did he write? Jasper Jones. Jasper Jones is the book that is read in Australia, that is very popular in Australian schools. By Craig Silvey. That's right, because Jasper Jones. Jasper Jones, a novel and a film and numerous stage productions. Yeah. But I know a lot of them are taking them off. A lot of them are taking his books out of circulation at the moment because of the charges. But again, he is presumed innocent until proven guilty. Where is he? No, that's not yet. Craig Silvey. All right, so yeah, so these are some of his books. Yeah, in a common, oh no, that's one of his books there. So yeah. Anyway, I'm going to love you all and leave you all. Thank you. If you could hit the like button, if you haven't subscribed or you had subscribed and you've stopped subscribing, please resubscribe. I hope you like my little shorts and stuff that I've been doing. A little bit of fun. I'm trying to just keep posting, even though I'm not live or can't get live. I just have lost. It's, you know, like today it was just even hard to get out of bed today. I just don't know what is wrong with me. I don't know. It's just been very hard to get anything. It's just very hard at the moment. I just can't move. I just can't get out of bed. Yeah, it's just, everything is just hard. So I apologize for that. I've got to just try and find, I'm just going to try and keep pushing through, and hopefully it will all work out. So yeah, I want to thank you for joining me, and I will catch you next time. And yeah, all right, until next time, thank you very much.